4CRB now presents Legal Matters, proudly brought to you by Bell and Senior Lawyers. Call them today for all your legal needs on 07 55 32 8777. This program provides general legal information only. It's not personal legal advice. Everyone's situation is different, so please seek independent advice for your own circumstances.
And as the promo says, it's a very good morning to Andrew Bell from Bell and Senior Lawyers. Good morning to you, mate.
Morning, Colin. Morning, everyone.
How was your long weekend?
Oh, it was great. The rain was a bit of a letdown to get things done, but it was always nice to have that extra day.
It is, isn't it? We didn't get it on Anzac Day, but we did get it very close thereafter. We've been talking, well, last week we were talking debt collection and loans. We got some great feedback from the program. We didn't quite finish the discussion, so we're going to finish that today. But this is a talkback program. It is all yours. So if you'd like some free legal advice live on air, all you need to do is give us a call right now on 07 55 208888. Do not leave it to the end of the program. We don't want you disappointed, so please give us a call this morning, 07 55 208888. All right, before we get into today's topic, can you give the listeners who missed last week a quick summary of what it covered?
No worries, Colin. We covered a whole lot of topics, not just debt collection, and hopefully we will today. Last week we celebrated my wife being admitted as a solicitor in the Supreme Court. We went through the difference between powers of attorney and advance health directives, where the key point is the advance health directive overrides the enduring power of attorney for the specific medical decisions it covers. We discussed codicils in wills, which are an additional document that edits a will, and why it's preferable just to draft a fresh one these days. We looked at the costs of wills, and then in terms of our main topic of debt collection, we went through what evidence you need to prove that something was a loan, not a gift. Went through the PPSR, the Personal Properties and Securities Register, and we looked at the limits of where you can sue. For example, up to $25,000 in QCAT through the Supreme Court for amounts above $750,000.
We have covered off a lot, haven't we?
We have. But I had other questions during the week, so there's even more to come.
All right. Well, let us start at the beginning. Last week, you said always get it in writing. What does that actually mean in practice? And we're talking about loan agreements with friends and family, aren't we?
We are indeed. So if you're going to a bank, they're likely to give you many pages and cover all eventualities. A loan agreement between friends and families doesn't need to be a lengthy legal document like that, but we strongly recommend if you are loaning money that you may want back at some point in time in the future, that before you give the money over, that you at least put something in writing. So at minimum, I'd recommend that you put in the full names of the lender and the borrower, the principal amount being lent, the date the money was advanced or was to be lent, and any repayment terms, if it's on demand, if there's interest applies, if it happens after a particular event, and also what happens if the borrower misses a payment. Both parties should sign it and then keep a copy for themselves. Even just a one-page document covering these points transforms an informal agreement into something that's much easier to enforce if you want that money back.
Absolutely. All right, this is a talkback program. We'd love to hear from you. 07 55 208888 is the number. All right, between family members, is that legally binding?
Absolutely. Provided it's between adults, a contract is a contract regardless of the relationship between the parties. Even husband and wife can enter into contracts. So a signed loan document between family members may do more good than one between strangers, because often with family members, the defence get raised, oh, that was a gift, oh, they never expected that to come back. However, if you have actually gone to the stage of formalising it, then that recognises it. If it was between two parties that aren't friends and aren't family, it's much more likely that money that was never intended to be a gift to a stranger. So definitely consider, if you are loaning money to friends and family, to put that in. Now, another question that comes up is if there's large amounts of money or loans against properties, you may want a solicitor to prepare a proper loan agreement rather than a simple agreement. A deed or a full loan agreement will give you stronger evidentiary weight and give you more rights if you need to enforce it.
Absolutely. Okay, well, that's great advice. 0755208888 is the number if you'd like to ask a question of Andrew this morning. What if you've already handed over the money and nothing is in writing? Is it too late?
Well, it's not too late if both people are prepared to acknowledge the loans. So people are often relieved to hear that you can do a deed which acknowledges that the historical amount has been loaned and the terms of that agreement. It's slightly different than a contract, but you record the original amount, the date that it was lent, the repayment terms, and then both parties sign it. And that document's now admissible as evidence in court or QCAT if that agreement later is denied.
What if the borrower refuses to sign anything retrospectively?
Well, then you're starting to get into problems, and that refusal is significant. My alert sensors would be coming up if I did hear that. It suggests that the borrower knows that it was a loan, and not acknowledging it means that they're unlikely to be paying it back. That's the point that I'd be going through every piece of evidence that we did have. Bank transfer records, text messages, emails, other people who might have witnessed it. And write to them talking about it.
Well, we've got our first caller, and we've got a little problem with our phone system, so we don't have names. We're going to ask you your name when we first grab the phone. All right, good morning to you. Could we start with your name?
Hello. Could I put you on to Lois Levy, the spokesperson for the Gold Coast Environment Council? Good morning.
Lois, we're in the middle of a talkback program. I'm just wondering whether that's what you phoned in for this morning?
Yes, well, I'd like to tell people that we have a number of people here.
All right, Lois, so I'll get you to give us a call back. It is good morning, Bob. Bob, ask your question of Andrew.
Good morning, Andrew.
Morning, Bob.
I have a reasonable property estate. I'm now in my 80s and I'm thinking seriously about my will, in which I've left the entire estate to my two children in equal shares. All my property is held in my individual name. My wife and I have separated and we've done our BFA. I'm wondering, will my estate have to go through probate, and if so, is there a smarter way to present my property to my two children, namely through a trust?
So, Bob, I would say that because you own property and it would involve the transfer on your death to another party, that it's going to have to go through probate. Now, whether that other party is a trust or whether it's in their individual names, that's still going to have to go through probate. The fact that you've done a binding financial agreement, a BFA, means that your ex-partner is unlikely to have any rights to challenge that. And if your children are the executors on the estate, I think that probate's probably something that you're just going to have to go through.
I'm thinking about should I transfer now the ownership of my properties into a trust before my death.
Okay, so if you're just talking about for ease, roughly the same amount of work's going to happen beforehand. There are potentially tax implications for capital gains tax, etc., depending on how properties are transferred. And I would recommend that you speak to an accountant if you are going to transfer things before you die, because that may or may not be the most tax effective way of handling this.
All right. Okay. Thank you.
Thank you.
Thank you, Bob. All right. We're moving on to Amber. Good morning, Amber. Ask your question of Andrew.
Hi, Andrew. How are you going?
Good, thank you, Amber. How are you?
Good. My mum passed away probably about 3 years ago, quickly, and she has a mobile home that my sister's currently living in. What's the process for us to sell it? Because it's not really a home; it's more like a van on wheels. So with her passing, there was no will because it was sort of, in hospital, died within 11 days. What's the process of me being able to sell it?
Okay, so if there is no will, this is where you get into a problem about who has standing over the assets in the estate. Typically, you would need to apply to the Supreme Court for letters of administration for someone to be appointed the executor. And then without a will, it would be presumed that her assets would be handed down according to the default provisions under the Act. From the top of my head, that would be if she had no partner at the time of her death, to the children in equal shares if there's children that survive her. So depending on what other assets she had, were there other assets apart from this mobile home?
No, she had a car. We sold that, and then basically sort of nothing else. She had a little bit of money left over that we got, but basically now my sister's in the house and can't really maintain it, so to speak. So there's like a deed of sale, like, if you purchase a van or a car, it's basically that, but it's not an actual deed like a home. So if I wanted to, I could take it out of the van park where it is and sell it separately. But just wondering what the process
You could,
was.
but the problem will be the standing if you try and enter any documents about registration or ending things, that you need to have the standing as the executor or representative or administrator of the estate to be able to do so. So depending on the value, but the official process would be that you should apply for letters of administration, get it appointed as the administrator, and then you could sell it as if it was your own property and then distribute it according to the rules of intestacy, which would be the equal share to all the children.
It's just myself and my sister.
So 50-50.
Yes. So, so do I have to go to the Supreme Court, or is it like if there's a...
Well, that's the recommended way to do things, because that gives you the legal title to be able to actually transfer any assets. And without that, you're not officially the administrator, so I can't recommend that you do it by yourself.
Okay. All right. No problem. Okay, no worries. Thank you for that.
Thank you.
All right, just a question, Andrew, on the back of that caller. If you don't go to the Supreme Court, or if you do, does it offer you a level of protection? If you've gone up there, you've been granted the right to distribute, means no one can come back later. Is that correct?
That's correct. No one else who potentially could have inherited, no one who bought something and says proper title wasn't transferred over. There's no allegations of theft or anything else that's going on. So you're protected if you do that. If you were to sell things, and often if there's not much value in the estate, people may decide not to go down that route. But the moment there's any valuable assets, it's definitely recommended to do it the proper way.
Great stuff. We move on to Lois. Lois, good morning to you. Ask your question of Andrew.
Well, I wanted to tell him about the council meeting in regard to a proposed cableway to Springbrook National Park.
Is it a legal question, Lois? Because at the end of the day, this is a legal talkback program.
Okay, well, yes, I guess I can make it a legal question in terms of the EPBC Act and the Nature Conservation Act and the Native Title Act, those sorts of acts.
So how can I help you, Lois?
Well, I was wondering if your legal person there could give us some advice on how to proceed with opposing a cableway to Springbrook National Park based on various acts such as the Environment Protection Biodiversity Conservation Act and also the State Nature Conservation Act and, of course, the Native Title Act.
Well, it sounds like you're a long way down that path already, Lois, and that's something that would require specific advice on that is a bit difficult to give on this general program, but I do know there are groups looking at opposing it.
Yes, they are, and of course...
and two of my solicitors live on the mountain, and I'm aware that there are actions being considered.
Excellent. Well, that's good to hear. Yes, I'll certainly pass that on because we don't believe a cableway can be constructed through a World Heritage Area without the permission under those various acts.
Lois, Look, unfortunately, your query is a large one and is probably not able to be answered on this program, but it does sound like from Andrew's answer that there are groups looking into it for you, and we wish you the best of luck in the future. All right, well, we're moving on. And did we adequately answer what if the borrower refuses to sign anything retrospectively?
I think we did. But yeah, so if they are refusing to acknowledge that you loaned something, and you definitely have, start gathering your evidence, because it's probably going to be time, and officials and court processes may have to be involved. And one note is any partial payments that have been made are very important to record down, because they're an acknowledgement of a debt if they can't be explained any other way as to why those payments were made, and can be used to evidence the whole debt.
Okay, well, that's an interesting one. So does just a bank statement showing that the money left your bank account and moved into their account suffice to that?
So we discussed a bit last week, but any of these things are on the civil standard in court. So it's not beyond reasonable doubt like the criminal standard. This is it more likely than not that something happened. So if you had a text message saying, yes, mate, I'm going to pay you tomorrow, and then there's a bank transfer of that amount coming through, if there's a transaction that says, Robbie, and it says $50 towards my debt, something like that in the lines, these are all indicative, if you're trying to go to a court or tribunal, that would indicate that this wasn't a gift because someone's actually tried to pay it back and they've acknowledged it.
Okay. All right, we might go to a word from our sponsor. This is a Talkback program. We'd love to hear from you. 0755 208888 is the number to call, and don't leave it too much longer.
Wills, probate, powers of attorney or property matters are legal issues that can feel overwhelming. Don't put off dealing with them. Call our trusted sponsors, Bell and Senior Lawyers. They explain everything in plain English and guide you through every step of the way. For caring, experienced advice, phone 07 55 32 8777 or head to bellsenior.com.au today. Bell and Senior Lawyers, making legal matters simple.
Welcome back to Legal Matters, and you're with Andrew Bell from Bell and Senior Lawyers. Not to be confused with the old sponsor, it is Bell and Senior Lawyers, the brand new sponsor of Legal Matters. All right, 0755 208888 is the number to ask a legal question of Andrew Bell this morning. 7 minutes left in the program, and we'd love to hear from you. All right, we don't. Thank you, Andrew. I missed one. I was just about to ask another question, and John's chimed in. Good morning, John. John, ask your question of Andrew.
Yeah. Good morning, Andrew.
Morning, John.
Andrew, Beach Bar news recently, and my question is, does a proponent for a beach bar require a permission from the state government as well as council to operate that commercial enterprise within a bathing reserve or on the beach?
Look, this isn't something that I've specifically researched, and there are provisions in the Planning Act for the state government to override planning decisions and take them over from the local government, as there is for federal government, but I don't know more about the issue than you do, John, so I can't comment on that.
So,
look, thank you for that. Sorry.
Yeah, you're right, John. Look, this is a legal program, and I do understand that was a legal question. It is a bigger question that this program can handle. My suggestion would be availing yourself of your local members straight away and taking as many people as you can with you and posing the question there.
Look, that's very good advice. Thank you very much.
Thank you, John. All right, 0755 208888 is the number to call. We'd love to hear from you. 7 minutes in the program. It must have been a little bit more than that when I said that last time. Moving on, forgiving a debt. Are there tax consequences?
Yeah, so sometimes people decide they don't want to pursue a debt, and I've been asked what happens, can they just let the debt go? Now, you can, absolutely. It's a private right. You don't have to enforce any debt against anyone. However, you need to be aware that there's potentially consequences. So it depends whether you're loaning to a commercial entity or from a commercial entity, or So, for example, if you have a family trust and you're loaning to your family, it may be a different consequence than if you're loaning individually, and same if you're loaning to your brother or your brother's company. And each of these has different consequences, and you need to be aware and get financial advice if that's the case. There may be exceptions for love and affection if a loan is between two individuals. However, that may also then be considered a gift by Centrelink, which may affect pensions and other bits and pieces. So be very careful if you're going to forgive a debt about how you document it and what situation you're in before you do so, because you can't unforgive it once it's forgiven.
So yes, a little bit of advice goes a long way would be probably the golden rule there. 0755208888 is the number for you to call this morning. Get a little bit of free legal advice live on air. We'd love to hear from you. 5 minutes left in the program. So it matters who made the loan?
Absolutely. So if it was made by a family company rather than you personally, then that love and affection exception doesn't exist, and then the tax rules may come in. The cleanest way to forgive a personal debt is with a deed of forgiveness, which is a simple document that records that the debt isn't going to be chased any further. Emails or just telling someone don't worry about it may not be sufficient if it ever comes to court or the ATO starts asking questions.
Okay. All right. So we're moving on now to debt collectors and what are your rights? And let's flip to the other side. What if someone is being harassed by a debt collector?
Okay, so over the last few years, the law has been strengthened quite a lot to protect people from debt collections. So under the Australian Consumer Law, a debt collector can't use physical force or coercion. They can't call you at unreasonable hours. They can't contact you an unreasonable amount of times. They're not allowed to discuss any debts that you owe with your employer, your neighbours, your family, in any way to try and embarrass you without your consent. And they can't make any threats unless they're legally entitled to make those threats. There are penalties if they do any of those things. And a lot of these are big ones. I hear about debt collectors that have supposedly said, if you don't pay this, I'm going to go to your workplace and embarrass you, or I'm going to tell your boss how much you owe. Well, they can't do that. And they're also not allowed to mislead you on how much you owe. And they're not allowed to give you any legal consequences that don't actually exist.
Fantastic information. All right, we've got another caller. Don't forget, couple of minutes left in the program. 0755208888. Good morning, Jason. Ask your question of Andrew.
Hello.
Morning, Jason.
Morning, how are you?
Good.
Just a quick query. I work on the road. I called into a restaurant at Mermaid Waters yesterday, like a big food chain, and I asked to use the toilet to wash my hands before I ate my meal, and they said that they don't have toilets. And I'm just wondering, how a big food chain servicing hundreds and hundreds of customers a day is able to operate without even having a toilet on site. Is that legal or no?
Well, that's a very interesting question. We do planning and environment law, and sometimes there are minimum requirements for a business, and that may be to have proper toilet facilities and wash-up facilities and end-of-day facilities for employees. But whether they are required to be accessible to the public depends on the individual approval for that particular business. So I don't know in this particular case whether they were mandated to and they've just closed it, or whether they didn't have to offer one in the first place. But I suspect there would have to have been a toilet on site or readily accessible for the staff.
There was one. It was in a shopping centre complex, but it was about 500 metres away. Being a public holiday, it was closed. So I'm just like, I just wonder how they service their actual customers, that's all. Is there any way I can follow it up, just out of general principle for, like, my own peace of mind? Like, is there... Like
my understanding is this would be regulated by the building code, copies of which are available online. I think it does relate to also the number of seats and whether they're licensed to whether the approvals happen or not. So I'd go down that line if you were curious.
No worries. I appreciate your time this morning.
No worries.
Thank you very much, Jason. All right, we are in the final minutes of the program. If you're quick, you could get your question in 0755208888. Rounding off, what should someone do if a debt collector is crossing the line?
Yeah, so if you do feel you're being harassed or threatened or unduly badly treated by a debt collector that goes beyond what we just discussed, my first suggestion would be to put it in writing to the debt collection company themselves, objecting to it. If it continues after that, the ACCC, ASIC and the Financial Services Ombudsman are all available to take complaints. A debt collector who breaches the harassment provisions can face criminal and civil penalties. And just because you owe money doesn't mean that you're not protected from that. So, put in a complaint and follow it up.
Fantastic. All right, Andrew, we are at the end of the program. Would you like to do a little summary?
Yeah, well, I think it comes down to what we said last week. If you're borrowing money and it's money that you can't afford not to get back, make sure that it's in writing. If you're forgiving debts, make sure that you're aware there may be tax consequences. It is possible for you to document a loan after the date, and we talked a little bit about what evidence is involved in collating a loan. And then I'd also like to put in when should you get a solicitor involved in debt collection matters. And pretty much my rule of thumb would be if it's over $25,000, then it's magistrate's court if you want to chase it, and costs are available in that regime, so I would avail myself. Second, if you've received a statutory demand, if there's any mortgage in possession or debt or repossession actions, or if there's any other complicated factors that make it difficult to evidence that the loan existed, then a legal professional should be able to make it much easier than doing it by yourself.
Well, Andrew, great information this morning. We never, ever get to the end of the topics, do we? But thank you very much for your time this morning. Thank you all to the callers that called in. We did have a few political questions. We do have political segments, both state, federal and council. Perhaps those are the correct forum for those questions. All right. Thank you very much for your time this morning. Andrew Bell from Bell and Senior Lawyers.
Thank you, Colin. Speak to you all next week.
You've been listening to Legal Matters, proudly brought to you by our trusted sponsor, Bell and Senior Lawyers. Call them today for all your legal needs on 07 5532 8777. A copy of this and past programs and all relevant resources will be available for you to replay or download on bellsenior.com.au and 4crb.com.